Court, all rise, please. The Honorable Judge Locke is now presiding. Courtroom 906 is now in session. You may be seated. Thank you.
The record before the court is the matter of Commonwealth versus Aaron Hernandez, docket 14-10417 and docket 15-10384. Mr. Hernandez is present in court. Your Honor, this matter appears before you for a hearing on motions. Will all the parties please identify yourselves for the record?
Good afternoon, Your Honor. Patrick Caden for the Commonwealth.
Good afternoon, Teresa Anderson for the Commonwealth.
Good afternoon, Your Honor. Mark Lee for the Commonwealth.
Ronald Sullivan on behalf of Mr. Hernandez.
Jose Baez on behalf of Mr. Hernandez.
Good afternoon, Judge. Robert Proctor on behalf of Aaron Hernandez.
And George Leontine on behalf of Aaron Hernandez.
All right, good afternoon all. We've got some motions to address, or at least to focus a little bit on, and some other matters to discuss as we aim towards the trial of this case. By my count, Mr. Baez, I think we have 4 defense motions that have not yet been ruled on that were previously filed. 2 motions relating to remedy for loss of tangible evidence. There was a motion to view the facility and documents of the Cure Lounge, and a motion for discovery of expert and scientific evidence. On the motion for discovery of expert and scientific evidence, I haven't ruled on that at the party's request over several hearings, as you were attempting to come to an agreement on the appropriate disclosures. And I see today a joint agreement has been filed. Was it filed today?
Yes, it was, Your Honor.
All right, Mr. Sheehan, change your deed stamp. All right, in light of the joint agreement regarding defendant's motion for discovery relating to experts and scientific evidence, is there anything outstanding with regard to your motion, Mr. Baez?
No, sir, there isn't.
All right, and the joint agreement will be filed with the court, and no ruling made on the motion by agreement of the parties. As I recall it, there was a view of the Kira Lounge that you all did by some arrangement that you had made with the lounge. Did that take place?
Yes, sir.
And Mr. Baez, the motion for, or motion in limine relating to the loss of Cure evidence, I guess, Cure Lounge surveillance evidence, that seemed to be a little dependent on what you discovered during the view, so, or the inspection that you had. So tell me where you stand with regard to that motion.
I think where we stand with that motion is that I believe the court, I would like an evidentiary hearing on this issue. There are new statements that conflict with previous statements given to law enforcement.
Statements by who?
By the employees at Cure,
Yeah.
for which we obtained during the inspection process. In addition to that, we had an installer there that installs these types of security systems that raised some issues that we believe would assist the court in determining whether or not the defense has reached its burden to possibly receive some type of remedy as a result of this issue. It's a critical issue to the case.
Tell me what the issue is. I'm not sure I fully understand it.
There are video cameras outside of Cure and at the very front door where there's, I believe, four cameras in total that were turned over to the defense. One includes a outdoor sidewalk view. Another one is an outdoor kind of line view where people make the where people get in line to come into the nightclub. And then third is one where people enter the nightclub and they're in the foyer area where they pay, or they show their ID and it gets scanned. So there's actually 5 cameras, I'm sorry. After that, I believe there's a total of approximately 30 cameras inside that mysteriously have disappeared. The very issue, or the state's motive in this entire case, revolves from some allegation of a spilled drink. Someone spilled a drink on Mr. Hernandez, therefore he's so enraged he waits 2 hours lying in wait to shoot these individuals for this specific reason. It is the centerpiece of the prosecution's case as to why Mr. Hernandez would do something so outrageous. In fact, it's also in the jury questionnaire statement that we'll be arguing at a later point. Aside from how outlandish the statement is, I think it's our position that of course never occurred.
Yeah, I can see where a video, if one existed, showing the bumping or spilling could be relevant and important to both sides.
Or the lack thereof.
Or the lack thereof. It seemed to be, if there is such a video showing that bumping and spilling, the Commonwealth would love to have it. Similarly, if there's video showing that no such contact occurred, you'd love to have it. As I recall the issue, you had a video expert familiar with the technology that was used who said it can't be that you have some videos recording and others not recording. That doesn't make sense technologically. And that was, I thought, something you were going to examine during the review or the inspection.
Yes.
Did you do that?
Okay. What we, obviously because the club had counsel present, which basically acted as somewhat of an obstruction as to us actually being able to fully do an inspection the way we wanted to. He did ultimately relent and allow us to question some of the employees. We had our experts look at the system to see if that's possible for us to do. We are going to be subsequently filing something for the logs in the system that would tell us whether certain things were deleted or not. I think that would assist us in that regard, as well as being able to present some type of evidence to the court that perhaps these cameras were in fact deleted. Now, there's another part of the issue that I think you need to be made aware of, and that is that law enforcement tells a different story than the employees at CURE. There's a complete conflict in the statements as to whether or not they were asked for and recovered by the employees at CURE. That needs to be hashed out. I think that
What is that? What's the difference?
Well, the difference is
Do
CURE
I
is
take
saying
it the
they
police
never.
are saying they went in, they asked for everything, and this is all they got?
Correct.
And if I recall at one of the hearings, it was reported that Kira said, we don't have film for the inside.
Correct, but that's not
At
what it
least
said.
that's what the police say they were told at the time.
Correct.
Okay, so that's the police version.
CURE version.
Now you say there's a second version.
Yes, CURE version now,
Yeah.
whether it was told to them differently or not, we need to hash that out. The CURE version is that they were only asked for the outside. They later came back and asked for a second portion where they were trying to identify a female patron. And then after that, they came back a third time, but by the time they came back the third time to get the incident indoors, it was already written over. That's
Meaning
not
that
what was told to law enforcement the previous time.
Is that a way of saying that Kira told you folks that there would have been recordings made at the time and preserved for some period of time, and then there's a rollover?
Yes, that's correct.
And by the time the police came back for the inside, it was too late.
Yes.
Okay.
But this is obviously a.
Well, if they told you that, And that is what you would expect someone from here to testify to. Then why do you need to inspect the logs as it relates to seeing if deletions were made?
Logs will tell us who's telling the truth, or give support to one's version or the other. Here we have we have two different versions of what actually occurred.
Yeah.
Obviously, something's rotten in the state of Denmark here, and we need to get to the bottom of it because it relates to Brady information, which is critical to both sides. I believe that the tapes would help exonerate Mr. Hernandez. State feels otherwise. The state feels it would give them a motive. So I think it's in the interest of both parties to find out, to get to the truth, and to, one, if we're able to meet our burden, receive some type of remedy. Obviously, it would all depend on what we're able to uncover. But I think there's clearly an issue here that needs to be hashed out. I know we're getting short on time. I know there's tons of issues to address, and I'd like to address that at a later time when the court gives me that opportunity. But as it relates to this specific issue, I think it's a critical case because it's step one in the entire case. And without step one, it may change the complete complexity of this case.
Mr. Hagan, what do you say?
Your Honor, respectfully, I suggest there is nothing to be sorted out, and quite frankly, there's nothing to be accomplished by an evidentiary hearing. One important fact that Mr. Baez did not mention to the court is there is still an open and live question that, quite frankly, will never be resolved as to whether or not any video ever existed in the downstairs of Cure. And why I say that is because there was testimony before the grand jury, and there was also confirmatory statements by the employees at Cure during our visit that at the time of this incident, they were having repeated problems with their DVRs. Just by way of background, in 2012, Cure had a total of 16 cameras, 8 which encompassed the upstairs and outside areas of Cure, and 8 that purportedly encompassed the downstairs dance area and the bar area of Cure.
Hold it. I thought I heard there were 30 inside here.
There are 30 cameras now, and if Mr. Baez has a different memory, then I guess we can discuss that, but according to Cure personnel, now they have 30 cameras, now they have 3 DVRs, but the best recollection of employees at Cure and the best information we have from what was told to detectives back in 2012 is that they only had 16 cameras total, 2 DVRs, and they had repeated problems with one of the DVRs that did not record. So it was not unusual, as testified to in the grand jury, that they would get video from the upstairs, but not the downstairs. So that's one important point to bring it out to the court. So a hearing is not going to recover this video if it ever existed. And again, in fact, there's no evidence that the video did exist. To the extent that there are differences in recollection of what transpired, the Commonwealth's position is that this is adequately addressed through cross-examination, perhaps vote-in arguments during their closing arguments. Essentially, the Boston police state, as the court stated, that they asked for everything. They asked for upstairs, downstairs, everywhere.
Well, I didn't state it. I said that's what I recall. I think you arguing.
Exactly. The Boston police reported, and one of the individuals from Cure testified in the grand jury that was basically the case. But again, Mr. Baez is correct that now employees of Cure have a different memory. They believe that there were 3 separate requests. They believe that there was an initial request for the outside. They think there was a second request to see some interior cameras, including the ID camera. It's also important to note, Your Honor, that there were 8 cameras that recorded were secured and turned over to the defense, not 5, 8. The employees of Cure indicate that there was a second request for the interior lobby area, which included the ID readers as well. And the employees of Cure then believe that there was a subsequent request for the downstairs video made by the police. The employees from Cure do not know whether or not they actually had video, whether or not the DVR was working or not. What they indicated is that obviously if the DVR was working, they would have had video from Cure downstairs, but that by the time they got that third request, it would have been overwritten by the system. Another important point for the court to recognize, particularly as it relates to any alleged negligence or malfeasance on the part of the police or prosecutors, is that there was no indication initially that anything happened downstairs in the club. In fact, all of the witnesses were interviewed extensively by Boston Police homicide detectives and indicated that nothing happened in the club. No disputes, no pushing, no anything.
When you say all the witnesses, who's that?
That would be the surviving victims in the car, as well as some patrons of the club, a couple of employees of the club.
All right.
All indicated no problems whatsoever in the club. And again, that just goes towards whether or not it was reasonable for the police to request the downstairs. But again, the Commonwealth's position is that they
Am I
did.
correct in recalling that you first learned of the spilled drink scenario from Mr. Bradley?
That's correct.
Was that 2013?
That is correct, October of 2013. So essentially, Your Honor, the position is that there's nothing that can be accomplished through an evidentiary hearing. There's no further action of the court that needs to be done on this. Obviously, it's an open question. Counsel can freely explore it through cross-examination, and as I mentioned, through a vote and type of argument closing.
With regard to the inspection that you all had, who was there? Who went on that?
Myself and Mr. Lee for the Commonwealth, along with some, two Boston police detectives.
Yeah.
For the defense, I believe it was Mr. Baez, Mr. Sullivan, and a number of their experts.
Yes.
And were any reports generated as a result of that? Did the police write any reports?
No.
May I respond to three brief things?
Yeah.
That was stated by Mr. Hagan. As to the number of cameras, I have no reason to argue with Mr. Hagan. Well, essentially what I'm arguing is it shows the same thing. All you can see is sidewalk, side alley, the front entrance, nothing more. However many cameras it takes to do that, whether it's 4, 5, 8, I don't know. Bottom line is, once you walk into the club, everything that's going on in there, whether there's simple dancing, to romancing, to drug dealing, to fights, to anything going on, all of that's gone. Now, there is a log that is stored in the hard drive of the system that would go back that far, that does not take up that much space, and that is not deleted or overwritten. That's what we were able to uncover based on the inspection of the system, for which we would be submitting a subpoena for.
You did not receive that log during the inspection.
No, we did not.
Did you ask for it?
That's kind of what, it's like a computer where we would have to copy the hard drive, so to speak, and be able to pull the log and look at it. And basically, it would inform us
Yeah.
whether
Did you
the
ask
user
for
went
it?
in. I'm sorry?
Did you ask for it?
No, because we didn't know this until after the inspection, where we met with our experts. We weren't able to freely discuss everything right there and then in front of everyone. It was a very guarded process, a very guarded inspection, where initially counsel for Cure wanted us to ask him the questions, and then he'd go and ask the employees the questions, and then him relay to us what they said, and so on and so forth. I mean, it was really, eventually he allowed us to speak to them within his presence, but it was not a very open process.
Yeah. Lawyers have a way of doing that.
Yes. Now, as it relates to Mr. Hagan's position about law enforcement finding this out in 2013 with the spilled drink incident, you're still dealing with a situation where two individuals are dead who just came from a nightclub. They specifically went to that nightclub and asked them for the cameras and for the video. The spilled drink incident, granted, none of the witnesses were saying that, but two of the 5 individuals in that car fled and left the scene. You don't have to be the Keystone Cops to be able to say, hey, we need to look into what activities were taking place in that nightclub at any specific time from the moment they arrived, and to investigate this case thoroughly, or no, just to investigate it, period. The cameras outside showed nothing, especially since where the incident occurred, there were no cameras. So I think it stands to reason, regardless of Mr. Bradley coming along later on and changing his story, that, and claiming that this all started from a spilled drink incident, that law enforcement, to do any type of investigation whatsoever, would have had to have asked for the video of what happened in the nightclub. And they specifically said they did.
Got it. All right. To the extent you intend to supplement the motion you filed, or to supplement or refile a motion for documents from Cure, records or computers, whatever it is. That has to be filed, and it has to be filed in very short order. Once filed, to the extent it's a request for further documentation or computer entries and whatnot, that would implicate Rule 17 such that the Cure has to be given notice, and we set up a hearing where they have an opportunity to object. And then I determine the relevance of this study and whatnot under Law&Crime. So you have to make that additional showing to the extent that something more you intend to submit. I'm not ruling right now on whether or not I'd grant an evidentiary hearing. I have some question as to whether that's necessary, but I want to see what more you file. And that will have to be filed, as I said, in fairly short order. Now, I have defendant's motion in limine for loss of tangible evidence relating to a vehicle, the BMW at issue in this case. As I understand it, that's somewhere over in the Soviet bloc, or?
That it is.
Is it the Republic of Georgia?
Not the state, yes, sir.
All right. You don't intend to bring it back. Let me hear you on that motion.
Sure. Before, respectfully, if I may, I have something that I'd like to bring to the court's attention before we address that issue, if I can.
Yeah.
And I really just simply have to lay out, if I can do it in, I guess, 100 seconds, if I may, of where I need access to Your Honor's patience, I suppose. We would, at this time, renew our motion to continue on this case. I'd like to make this or attend this motion based on numerous factors. And we are really working around the clock here to keep pace. As we work around the clock, the prosecution is continuing their investigation. This morning we were handed a new thumb drive, which I can tell you, along with 2 other disks of discovery, some of which, to their credit, has been turned over as soon as they're getting it. But I think this is the official version of everything that's going on. What's going on with this investigation right now is it's continuing. And they are going off and speaking to witnesses in all over the country. We've got new statements from people in Arizona, Florida, and I think other states as well. I can't keep up. I simply can't keep up. Being on a case 6 months, where it's essentially 2 murder cases wrapped in one, and oh, by the way, it's high profile, which means we are leaving no stone unturned and sparing no expense to prosecute an individual. It is essentially an impossible task to effectively represent Mr. Hernandez. We are filing motions, getting rulings by the court. Specifically, I'll tell you, the tattoo motion, which Your Honor just ruled on. We come to find out there's case law that might assist our client's position and completely show the court that this is a case of first impression, of which this
On
is...
the admissibility of tattoos?
Yes, sir. Yes, sir. Now, having said that, the key issue is, the problem with that is, we would have loved to have been able to argue it, but we're trying this case ghetto style, where we're just filing motions without being able to follow up with proper memoranda of law and proper research to be able to back it up. I don't practice law that way, and neither does any of these lawyers. And I understand the court's position where I've got great lawyers by my side, but there's one problem. To try the case, the lawyer, lead counsel, co-counsel must know everything. And to be able to, I'm still catching up, much less finding where I feel an obligation, and I have my ethical and professional responsibility to Mr. Hernandez to file specific motions that could be dispositive in his case. As you see, we filed, I don't know, the court's count is better than mine because I have no idea. I'm literally trying as best I can to stay on top of everything that I can. And the state's doing a fantastic job by keeping it going. And I'm not alleging gamesmanship, but, you know, it's sound strategy as far as I'm concerned. Keep us behind the 8 ball, and if the court holds us to this date, all it will be doing will be assisting that, which I think would be clearly a violation of Mr. Hernandez's due process rights.
When you say assisting that, what is the that?
We are behind. We are so behind in this case, where we're basically getting flooded with more information every day. We have not had the ability to properly speak to every witness. They're going around speaking to witnesses 2-3 times, getting multiple statements from these witnesses, and at the same time, we still haven't gotten around to speaking to them once. And I think in total of 120 witnesses that the state may or may not call, I don't think it'll be that high, but out of the 120 that we have the professional responsibility to review, we've only spoken to 5, 6. We're just so far behind on being able to get all of this legal work done, and at the same time get caught up on the case, and at the same time get caught up with the new information, for which I will tell you, and I believe we'll be addressing this today. There is now maybe a new theory of prosecution that may be coming to the forefront, for which this case now has to be turned up basically upside down on its head. It is by far the most unprepared that I have ever been in a courtroom in any case across this country and in my entire career. I know my co-counsel, Professor Sullivan, feels the same exact way as well as Mr. Leonaire. We are going to do whatever this court orders. I just have no other way of trying to express, and I have that responsibility to Mr. Hernandez, where all I can do is kick and scream and advise the court of all of the issues. I will also advise that we have, and this isn't waiting or any type of games that we're trying to play. We will be taking up one interlocutory appeal, I believe, tomorrow. And possibly 3 more next week. I'm trying to be as frank with you as I can. I want to try this case. I want to do it as soon as possible. I think this case deserves justice on both sides, but I think not having the ability of both sides being prepared would do a great disservice to not only Mr. Hernandez, but to all of those involved in this case. And I renew my motion for continuance based on that. And I would ask that the court consider that. Maybe before you reject my motion outright, let us get through the day and you can see.
Well, it's not rejecting it outright. I will tell you that. And I'm considering all that you said, Mr. Bias. But you're not new to the courtrooms.
No, sir.
You're not new to the trial process. And I'm sure you've had many a case, perhaps every case, as any trial lawyer likely has had, where as one approaches trial, one develops new information. One re-interviews witnesses, and something different comes out. That's part and parcel, it seems to me, of the trial prep process. And we all account for that. To the extent the Commonwealth is being overly cautious in advising you every time they speak to someone, every time they interview or re-interview a witness, engage in trial prep, it's commendable. But it's not necessarily new information or information likely to cause surprise. To the extent the Commonwealth is developing evidence that is truly a surprise, that is untimely, and that creates prejudice based on late disclosure, there are remedies for that. and you, I'm sure, are aware of them. You could file a motion to exclude or limit evidence, and I'll be happy to consider it. I don't know what's on the little thumb drive you've held up today, and how much of that is truly new and unexpected or surprising information. And if it is shown that the Commonwealth in some way willfully withheld it until now and surprise and ambush the defense, there's a consequence for that. And I'd be happy to hear about it. As to the trial date, generally, we've already discussed that. And I would be inclined to hold to that trial date. As to your ability to prepare, as I said before, quite a battery of very competent lawyers, each focused on, it seems to be, on different aspects of the case or different issues arising in the case. You reference interlocutory appeals, and there obviously is that right under the Massachusetts rule. And I think, is it Rule 15 that gives a 15-day time period for the docketing of decisions? And certainly avail yourself of those rights. I would not be inclined to grant a stay other than the 15-day rule requirement, although a single justice or a full bench would grant a stay. But unless that happens, it seems to me we ought to shoot for February 13th. Now let's understand what's going to happen on February 13th. We begin impanelment. I must say I don't think this is going to be a one-day impanelment. And I suspect that there'll be a good deal of time involved in that process, which may require the attention of some lawyers, but not necessarily all. Certainly wouldn't involve the intention or attention of any investigators. I would assume you have investigators out assisting you in the preparation of the defense. And so, although we have a starting trial date, it may be well into the following week before we begin to receive evidence. That's additional time that you have to be familiar with what it is the Commonwealth intends to or wants to try and present. It's all a way of saying that I'm not inclined right now to continue the trial date. As to the motions that are being filed, I've tried to help you all in focusing on pretrial activity by setting filing dates. There's been some compliance with the filing dates I've set, and then some motions that seem to be filed after I've set filing dates. I haven't yet excluded any motion as untimely, including the 7 motions that were filed, I think, last night on behalf of the defendant. We'll take them up in due course. I don't know how many more motions you're contemplating, but let me tell you, at some point they become untimely. So keep that in mind. Anything else?
No, Judge, that would cover everything. I think I sufficiently laid my record, and I appreciate the court's involvement.
As I indicated, we've received some further defense motions today. A motion to subpoena or examine records of the Palm Beach Sheriff's Department and evidence that they may have. Let me ask Mr. Hagan. I take it Palm Beach is connected to the Bradley shooting.
That is correct.
Is there evidence from Palm Beach that the Commonwealth has received?
Everything the Commonwealth has received is in the arena, so to speak, of documentary and photographic evidence. All of that has been provided to the defense. The only additional evidence that I believe would be subject to inspection would be a shell casing that was recovered from the scene and a piece of a projectile that was purportedly removed from Mr. Bradley's face in surgery.
Was the shell casing, it was not shipped to Boston for
It was not.
analysis?
It was not.
Was it analyzed in Palm Beach?
I believe it was, and those documents have been turned over to the defense.
And then there was a bullet fragment of some sort?
I believe so, from the hospital.
Was that examined by the Commonwealth?
I believe that was not examined by the Commonwealth. No.
Was it examined in Palm Beach?
It was.
And was a report generated?
Yes, it was.
And those reports have been produced in discovery?
Correct.
Mr. Baez, with regard to that motion, is it focused on anything other than the ballistics that Mr. Hagan has referenced?
Yes, I've seen photographs of clothing that was worn by Mr. Bradley that we would like to have our blood pattern experts inspect and photograph correctly.
Yeah.
The photographs in this case are scant at best. They do not have, they're not properly taken of the scene. They're incredibly poorly documented. I think this case was, we may have an issue here, another spoliation issue where, due to Mr. Bradley's lack of cooperation, the Palm Beach Sheriff's Department decided, we're not gonna do anything here, we're gonna toss this case. And several months later, the Commonwealth comes along and says, we'll pick it up, let's just bring it to Boston. And that's where I think we're at right now. But it all revolves around the specific statements of what Mr. Bradley says occurred, of which he has clearly admitted he's lied. He lied to law enforcement, claiming that he didn't know who shot him. Now he knows, now it's Mr. Hernandez.
Got it.
So, and I believe there may be exculpatory evidence based on the small photos that we've seen already on the actual, on Mr. Bradley's clothing, that may be able to determine whether the events occurred as he says they did.
Got it. Have you had any contact with Palm Beach authorities with regard to trying to inspect what they may have?
Yes, sir.
And what's the result of that?
They have informed us that they will not cooperate with us without a court order.
Okay.
So I think the process that we have to go through is, of course, the interstate subpoena process, for which we would ask this court to grant. We got to go to Palm Beach, set that specific up, set that inspection up with our expert, and whether that leads us to any further information, I'll certainly let the court know as soon as possible.
Okay. Mr. Hagan, have the Boston Police or the DA's office had any, or have any continuing contact with the Palm Beach Sheriff's Department?
We do have some continued contact, not frequent. Most recently, in an effort to assist the defense, I did forward the name of the lead investigator from Palm Beach County Sheriff Department to see if he could facilitate the evidence review. We're certainly willing to make more phone calls and to assist the process, but I believe their procedure is they need a court order to allow access to the evidence.
When you say that, why?
That's what we're told from the lead investigator.
Did the lead investigator indicate whether they would recognize a Massachusetts court here?
He did not. He did also indicate, though, Your Honor, that they would make the evidence available to the state, being the state of Florida. So I can make inquiries as to whether or not our counterparts in Florida would somehow be willing to assist in setting this up, perhaps even with just a court order from Massachusetts, short of the out-of-state subpoena process.
Do you know if Palm Beach authorities have any continuing interest in the Bradley case, the shooting case in Palm Beach?
Well, I believe they do. We've had meetings with them. It's still an open case for their purposes, but as to whether or not they intend to charge it anytime soon, the answer would be no. But it's still an open, active investigation.
Let me see you over here.